everyone, and welcome to this edition of Judgment Day. I'm Lorne Honickman. Well, just a few hours ago, the Supreme Court of Canada, in a very important ruling, has unsealed the estate files of slain billionaire Barry and Honey Sherman. It was a unanimous decision. And this is a very, very important ruling in the area of law that we call the open court principle. And yet you may remember that this all came from the fact that Kevin Donovan from the Toronto Star, who was really the impetus behind this entire court case, back in 2018, wanted to access the estate files, like the wills, the last will and testament of both Barry Sherman and Honey Sherman, and found out that an application judge had sealed the records. And so it was his impetus. He took it right through. The Ontario Court of Appeal said that ruling was wrong. The trustees went to the Supreme Court of Canada, and today, as I say, in this unanimous decision written by Justice Caseret, the Supreme Court said, no, the open court principle in this case trumps the arguments as to why those files should be sealed. So let's talk about the significance of this case. I want to bring in a man that I actually met in law school many years ago, and we belong to the same organization called the Canadian Media Lawyers Association. Iain Mackinnon, who's the president. Welcome, Iain.
Thanks, Lauren.
So let's, right off the bat, let me ask you your reaction. You've stood in court as many times as probably any lawyer in this country, arguing for the open court and the importance of it. How important is this judgment today? Why don't we start there?
Yeah, it's very important, primarily because the court did uphold the open court principle and reiterated and reinforced that covertness is the exception and openness is the rule. And they also reiterated and reinforced that it's a very high bar, high threshold for anybody who wants to restrict openness and restrict freedom of expression and access to courts and court documents, that they reiterated that sort of longstanding principle that the Supreme Court has said is a fundamental aspect of any democratic society. And so that was heartening to see and important that they did that. And at the same time, they also put a lot of meat on the bones as to what privacy interests are sufficient to overcome or outweigh that open court principle.
Right. And because, and this was sort of the key argument that was put forward by the counsel for all the estate trustees and beneficiaries. And that dealt with the issue of privacy. And privacy, it was very interesting what the court said about privacy. But let me just read, and there are so many passages, Iain, that we can look at. But one of the passages that sort of stuck out for me, he said, a court can make an exception to the open court principle if the interest in protecting core aspects of an individual's personal lives bear on their dignity. And that could be at a serious risk by reason of the dissemination of sufficiently sensitive information. And it appears, and I want to talk about this, because the court talks about if you can show that there may be someone's dignity may be impugned, that seems now to be different than privacy, which didn't rise to the level necessary.
Yeah, and that's why I think the court and the judgment spends, so much time, a significant portion of the judgment is probably, 2/3 or 3/4 of the judgment is spent defining what that means, because there was always, as part of the balancing test that the courts have to do in these circumstances, when you're weighing important public interest, in this case, privacy, versus the open courts.
Right.
There's always a weighing exercise, a balancing exercise. Privacy interests have always been a factor that a court can always consider. The problem has been there hasn't been any clear a definition or guidelines as to what privacy actually means, because it's such an amorphous, large concept that it could be everything from just identifying somebody's name or address or where they work. That arguably could be private information, depending on the person, to something that's clearly on the other end of the scale, personal, medical, or health information that's very private and sensitive. So the court spent a long time in the judgment trying to define, as you say, that type of information that goes to somebody's, quote, biographical core,
Right.
and is so intimate, so personal, and so sensitive that disclosing it publicly would constitute a violation of their personal dignity. And so I like to start, I think I'm going to start referring to this judgment as the dignity judgment, because
Well,
I'd like to count the number of times in this judgment that the word dignity is used. It's got to be at least 20 times off the top of my head. It's constantly referred to.
well, and we're going to talk about what that may lead to. But before we get there, let's stay back on privacy for a moment, because there will be many people who will be hearing about this, listening, watching us, Iain, and saying, well, it seems to be intuitively obvious. Isn't it private what someone puts in their will, what someone has determined where they want their money to go, and all of these issues surrounding, disputes that may take place in a family. And it may be hard for them to reconcile and say, hey, listen, we don't care about your dignity concerns. Why would the court say, no, it's it's an open court principle. Everybody gets to know about that.
Right. And I think that's why the court went to such great lengths to say, okay, if you've got privacy as a big circle like
Right.
this, and things like what's in somebody's will and who the beneficiaries are is arguably falls under that big circle. But then within that circle, you've got this little circle of no, those privacy rights generally that everybody seems to accept as being private information is not what reaches the high threshold. It's only this small little circle of items and information that actually go to core aspects of somebody's private life and how they choose to express themselves, or how they want the public to see themselves as. That's this part of this personal autonomy they refer to in the judgment. Only that rises to the necessary level of being an important enough public interest, because that private interest that you and I and every other person has about controlling their own self-expression and the core aspects of their identity, only that information rises to the level of being important enough that it's a public interest, not just a private interest. But because that's so important, it's actually a public interest for all of us to have that protection. So it's not somebody's own personal experiences and personal information that deserves the protection. It's when it rises to a greater public interest that's important enough for everybody to have that right, is when then it may outweigh the other public interest of maintaining open courts.
Right. And that's why Justice Cazalet writes, an applicant will only be able to establish that the risk is sufficient to justify a limit on openness in exceptional cases. And here are the words here that I'm sure are going to be quoted by lawyers for years to come, where the threatened loss of control over information about oneself is so fundamental that it strikes meaningfully at individual dignity. And as you said earlier, what those words are going to be, we know they're going to be used again. And how are the courts going to deal with that concept on an ongoing basis?
Well, what I fully expect is anybody who's asking for a sealing order or even publication ban on any information that is considered, that falls under the general concept of privacy or privacy rights,
right?
They will invariably refer to, if this information was public or disclosed, it will be an affront to their personal dignity. And a judge is going to have to look at that and decide, is this truly an affront to your personal dignity? And that's what the court did. So they set out those general guidelines in the first 3/4 of the judgment. And then, as they do in every judgment, they then applied those principles to the facts of this case. And they said, look, the information contained in a probate file, in a will, a state's file that's for a will that's being probated, is just basic information about how a will is being distributed. There's yes, it's private, and maybe beneficiaries and trustees would prefer that information not be public,
Right.
and they're sensitive to it, and maybe it's even embarrassing, but that's not something that is, if disclosed, is an affront to your personal dignity. And that's why they ultimately said this doesn't meet the high threshold, because it doesn't go to your biographical core. It's yes, it's personal information, and yes, it's private in theory, but if you want to go through the court system, and a will has to go through the court system to be probated, there's an understanding that you are giving up certain privacy rights, but not everything. Not everything.
And there was another, of course, there was another layer here as well, Iain. This case also had arguments that unsealing the record, physical harm could take place. And I know Kevin Donovan's written about that in the past as to the potential, what that potential was. But even here, the court said no. They agreed with the Toronto Star argument that the probability of the physical harm was only speculative, and so they said it wasn't going to be determinative.
Yeah, and they spent less time on that because nobody disputes that if there is a real risk of physical safety, that's certainly something that could outweigh the open court principle. Obviously, we don't want somebody being injured or even killed for the sake of keeping courts open or access to court documents available. So that's not in dispute. The Star didn't dispute that either. So it really came down to the question of applying that concept to these facts, and was there a real risk or not? And the important thing I think the court noted in that section of the judgment is that they said, what is at issue here is not whether the affected individuals face a safety risk in general, but rather whether they face such a risk as a result of the openness of these files. So in other words, it's already public information who the beneficiaries are, for the most part, unless there's some surprises in the will, and even who I think the trustees are. So disclosing that information is not going to expose them to any more risk, and any other information that's in the will is not likely to expose them to any safety risk. There needs to be some type of evidentiary basis to suggest that there's a risk.
Right. And you don't need, as the court said, you don't need direct evidence. You don't need somebody saying, putting in an affidavit to say, I've been told that if I get any money in this, my life, you don't need that direct evidence. In fact, the court said circumstantial facts may allow a court to infer the existence of a serious risk of physical harm. They don't need to retain experts. But he goes on to say, but on this record, the bare assertion that such a risk exists fails to meet the threshold necessary to establish serious risk of physical harm. So you don't need direct evidence, but as you said, you need some evidence.
And it has to be, as they kind of reiterated from past cases, well grounded in the record or the circumstances of a particular case. So in this case, it just wasn't well grounded. I mean, they distinguished between something like this situation with undercover officers who are dealing with, criminal elements, who, if they're identified, then there is, it's much easier to infer that you're going to have a serious risk to their safety if they're, investigating gang violence or dangerous firearms offenses, as they point out. That's a very different situation. But in here, they just said there wasn't anything to even infer that that's the case simply because it's an unsolved murder. That's not enough.
And And I guess, I know you were lamenting, can I use the word lamenting? Talking about that this will be called the dignity judgment, but I think, and you hit this off the top, there is a lot in it as well about reiterating the importance of openness of courts. Um, uh, this issue dates back to 1993 when the Supreme Court in the famous Dagenet case first really um, talked about it being such an important charter right. So I think that for those of you like you, Iain, who spend a good amount of time arguing these cases, there is a lot in there for you to use as far as openness goes.
Yeah, and it was, of course, heartening to see that they, repeated and relied on previous Supreme Court judgments that talk about the media being the eyes and ears of the public, and the importance of the news gathering process to be able to have court access, and reiterating all those sort of motherhood principles that are always nice to see.
That's right.
So
The motherhood principles of openness. You've just created a new a new concept. Well, I guess I think you're absolutely right. I do agree with you that the issue of dignity is going to be brought up. But what I'm hoping for when you get rulings like this, and I think you'd agree with me, what I'm hoping for is that the courts on a go forward basis will be very careful not to simply fall into the trap, if I can use those words, that you're sort of suggesting that or showing the concern about, and maybe that as the cases evolve, we'll learn a little more about what really constitutes dignity and what that actually means at the end of the day. Um, and it'll be interesting as well, Ian. I'm sure you'll agree that in the light of this judgment, once the actual facts come out of what was being sealed, that will give us a little better idea, won't it, as to
yeah.
What the court saw there, because they saw this. They know what they're dealing with. They know what's going to be released, and I think that's going to be helpful to lawyers in the future.
Yeah, that's a good question. Do you know if the actual will was filed as evidence on
I
a
was
motion?
and I was just going to ask you
I don't know.
the exact same question, because I'm assuming that they must have known something about what's contained in the record to be able to say that whatever was contained in there doesn't meet this high threshold that we now call dignity.
Yeah.
So they had to have obviously some idea. I think that I'm assuming that they must have been able to know that, because they would have had to have done something in a vacuum. And that's why I think it will be important once we learn the information, because to your point, Iain, about what could happen down the road, when the argument comes up about, well, this should be sealed because it's this, it goes to the issue of dignity. One may be able to argue at that time, no, these are the exact same things we saw in the Sherman case
Right.
that didn't meet that level. So maybe
Yeah.
that's how it.
Or the other case that we often rely on too, Ontario Court of Appeal case that in the Colonel Williams case, who was
Right.
convicted of all the sexual
Yes.
assaults, and his wife had a divorce proceedings with him, and there was obviously a lot of personal and private issues raised in those divorce documents, and even that didn't meet the threshold of privacy rights. That was the other sort of big privacy case,
Right. Remember that.
versus open court principles that and I think it's cited in this decision too. But yeah, those are the kind of cases that we point to say, look, if that doesn't meet it, then certainly this doesn't.
Right. So it'll be interesting. Well, I guess as we say, we'll have to wait and see
Yeah.
when that first case comes before the courts and somebody wants to apply the Supreme Court of Canada judgment in Sherman and talk about dignity.
And
And
we'll know soon enough, I think, if not today, certainly I bet by early next week, what's in the will, because I know one reporter I was speaking to they were trying to get the will documents today after the decision was released, and
oh
he
yeah,
thought it
no,
was
no, and
50-50. So it might take another day or two before the court releases it. But
I'm guessing that our friend Kevin Donovan could have that in the online and in the papers tomorrow morning. So we will get a very good idea. Iain, thanks so much for joining me today. I appreciate it.
You're
Um,
welcome.
and
Anytime.
and we'll talk soon, and we'll keep an eye on how this judgment is used in the future. Appreciate it.
Okay. Thanks,
All
Lauren.
right, see you.
Bye.
Iain Mackinnon, and he is one of Canada's top uh, media law lawyers, as president of the Canadian Media Lawyers Association, and he's right. It is going to be very interesting to see how this concept of what is dignity as opposed to what is privacy. Privacy didn't make it in this case, even though it's a will. It didn't make it. And to Ian's last point about it's going to be very interesting. I had some email correspondence with Kevin Donovan from the Star. I was hoping he was going to be able to join me today with Ian, but of course, as can be expected, he was quite busy. This is a big day. This is, for some, I'm a big Kevin Donovan fan. I think he is, if not the one of the top investigative journalists in this country. He has been all over this case from the beginning, and it was his impetus, as I said, that pushed this case through the courts to where it is. And so he's obviously got to be very, very happy and should be proud of himself as to how as being the engine to get to the Supreme Court and to get a very, very important legal decision that will have far-reaching ramifications, as Ian and I talked about it. And it will be interesting to read exactly what was sealed and what it all meant. Not, again, and from my point of view, not just from a voyeuristic point of view as to, oh, who did he leave his money to and whatever, but again, putting this into perspective once we get the details as to what the court looked at as not being the type of private information that should rise above what we call that open court principle. All right, well, that is this edition of Judgment Day. Thank you so much for joining me, and until next time, I'm Lorne Honickman. Bye, everyone.